Earlier this year, we saw a news story about a family who bought a home in Epping in Sydney with the intention of demolishing it and building a new one on the site. It's in a suburban street. Seems like a reasonable assumption that they'd be able to get a DA approved, so they went ahead and they demolished before they submitted plans to Parramatta Council. And to their horror, the council advised them that they couldn't build on the site because it's in a flood zone. It got me thinking about what an urban planner might have to say about this tale of woe. And further to that, what other assumptions could be dangerous as we go about planning property improvements, whether we want to do something seemingly minor like building a new fence right through to a multi-unit development.
Welcome to The Elephant in the Room. This is the podcast where we love to talk about the big things in property that never usually get talked about. I'm Veronica Morgan, real estate agent, buyer's agent and buyer's agent mentor, co-host of Foxtel's Location Australia, author of Auction Ready and co-host of Your First Home Buyer Guide.
And I'm Chris Bates, mortgage broker, recently ranked number 5 in Australia out of over 18,000 brokers in the annual MPA Top 100 Mortgage Broker Awards. Before we get started, I need to let you know that nothing we say here can be taken as personal advice. We always recommend you engage the services of an appropriate and experienced professional.
Today we've invited an experienced urban planner to explain what's involved in gaining approval for property improvements. We want to know how easy it is to make devastating mistakes and, of course, how to avoid making them. Eli Gescheit is a Director of Navon Planning and an urban planner with over 15 years' experience. Based in Sydney, he knows the ins and outs of councils while also understanding the requirements of his clients, the property owners. He regularly appears as an expert witness before the New South Wales Land and Environment Court, so we imagine he may be able to share some meaty case studies with us today. Thank you so much for joining us, Eli. I'm looking forward to this chat.
Thank you, Veronica, and thanks for inviting me. Looking forward to it.
Ellie, we've done over 250 episodes. We haven't done too much on this sort of development space and the planning space in particular, and I think it's a bit of a gap in our sort of 5 years, I guess. Before we get into that, I know lots of juicy stories around maybe the flood zone or there's lots of things. Maybe it's a good idea just to sort of maybe just talk about the planning process. I think a lot of people don't really understand how it works and the different avenues, etc. And, as succinctly as you can, I guess, talk through, the general process people need to go through, whether they're doing a minor or major reno.
Yeah, good point, Chris. A lot of people just think town planning has to do with getting an approval for a house. Or usually when you get a refusal, that's when people think about town planners, Oh my gosh, the town planner refused my, new home or my renovation. But it actually comes a lot further on. You need to look at things a lot earlier on in the process. So I recommend people, whether they're looking to buy a property or they own a property, to get a town planner on board very early on, just like they would get an architect or a surveyor on board, because you need to have that thorough understanding of, number one, I guess, what are the issues that apply to the site, including flooding and heritage and bushfire, as well as what are the controls that apply to the site also in terms of, what's the development potential that you could achieve on the site.
So you get a town planner involved, but then they say you can do X, Y, Z, and then what's the process then, just in terms of talking it through, in terms of do you have to lodge it with council? What documents do you need to provide? What's the sort of process?
Yeah, so also a good question. So a town planner generally, I like to call them, we're an advocate for the client. So we're an advocate for the project. If it's a project, so we have to keep the design in check with the council's regulations. If there's an aspect of the design which might not comply, and we think, hey, it's give it a go, it's been done down the road or something like that, or the impacts are not as great as what council might think, then we might say, okay, we're prepared to support that non-compliance for various reasons.
Can we tease this out just a little bit? There's town planners that work for councils too, aren't there?
Correct. Yeah, so I guess there's generally two types of town planners, let's say. There's the town planners that you hear about at councils as well as state government, so in a government role. So they're the town planners that, I guess, assess applications, as well as there's a side of the town planning called strategic planning, where they rezone land and so the trains and the metro lines have to go here, all that, large scale planning. So that's, I guess, from the government point of view. From the other side of the fence, from a consultant point of view, so town planners can also be consultants, such as myself. So really giving advice to clients, as well as really ensuring projects get approved in a timely fashion.
And so when you say that you're the client's advocate or the property owner's advocate in pitching, I guess, the plans to the council, it sounds a little chicken and the egg. Do you go to the architect first and get the plans drawn up, or do you go to the town planner first and work out what the architect or constraints the architect should be working with? And in which case, why wouldn't the architect know that?
Yeah, you've got to do both, right? An architect can understand the council regulations, right? And they can, in a way, do what we do as town planners. But in saying that, what I tell architects is you need to know your experience and your boundaries. I tell them, for example, there's no way in hell that I would start, sketching a plan of a block of apartments, right? Vice versa, an architect shouldn't pretend that they're a town planner and they know what a town planner does and what, so you do essentially need those different, I guess, experts on your team. Yeah. I don't think you be a jack of all trades as much as I'd love to be one, but you can't.
It's the same on the property buying side of things. That we always say you got to stick to your lane. You got to know what your area of expertise is. Unfortunately, everybody thinks they're a property expert, so everybody oversteps the mark. But well, not everybody, but a lot of people do. Can we go back to the couple who demolished their house, in Epping that I read about in the intro? Because they basically then discovered they couldn't build anything on the site. And the news story at the time focused on this being very unfair. But, from a town planner's perspective, when you hear of a story like that, what do you think really is the story? Like, what is it unfair? You know what I mean? What could they have known? I mean, I can sort of guess what they should have discovered before they bought it. But what goes through your mind when you hear a story like that?
Well, there's obviously two sides to a coin. I did rewatch the episode last night just to refresh my memory about it. They did a few things wrong. They're naive. They were naive, just like most mum and dads are. They went with a project home company. Now, I'm a fan of project home companies, believe it or not. They are usually very good at building homes and all of that, but they're crappy at dealing with councils. That's where they fall short. And I've helped a few of them before, and they actually really need guidance. Even after I help them, they still need a bit of a push because they don't have that council insight into what goes on behind the scenes. I've worked in 2 councils before, so I kind of have a good idea what goes on behind the scenes and what are the expectations. So they made a lot of errors. I would say starting off, demolishing the brick home without approval. That was a no-no. I'm just going off what I've read in the article as well as what was in the on the TV. So that wasn't, demolishing a building without approval. It is a legal issue,
especially if it had some type of heritage overlay, right? Like it can be, you have to rebuild it like it was, and certain areas, the heritage facade, for example, could be extremely costly if you make a mistake like that, right?
You could get fined hundreds of thousands of dollars for doing something like that. Removing a tree without approval is also a no-no. All these things. And, what they did was they signed up probably with the best project home company, good price, and they were in their hands. I'm not having a go at project home companies, but I'm just telling you what I see, what was part of the problem for them.
Just step in for a sec. So, but a project home company should know you can't demolish a building without approval. You would think they do it day in, day out, right? And that's what I kept thinking. But who demolished it? It's a specialist job. Not anyone can go in there and demolish a home.
Yep.
Whoever demolished it there must be some negligence or there must be some contribution, to the whole problem there. But the other thing too is that the idea that, and it's erroneous, but the idea that, well, I bought property on land, so therefore I can do what I want. And a lot of people say, and I hear those words, I don't buy strata because I want to be able to do what I want. It's like you can never do what you want.
Yeah. Yeah, it's very true. So that was problem number one. Problem number two, well, problem number one was not doing the due diligence also in terms of the conveyancing and finding out, what are the issues on the land. usually with, as you would know, with any contract, you would have the 10.7 certificate, and that'll have everything in there, usually.
Well, actually, I'll step in there. When you say usually, the 10.7 is a prescribed document in a contract to sale in New South Wales, right?
Yes.
If you are listening to this and you're not in New South Wales, there's various names for it's a zoning certificate, right? So different states have requirements as to whether or not the vendor even needs to give you one, right? So you get one in Victoria, but you don't get one in Queensland, for example. But so are you saying that could be incomplete, that actual zoning document?
Correct. The two, so if it was flood affected, you would say yes on that 10.7 certificate. I say usually again, because what's happened is over time, councils have been slow in terms of adopting and updating their maps. So maps like flood maps as well as bushfire maps. So there's been a real delay in those, in transferring that information into this planning certificate, which is, I've been involved with projects where client bought the land and found out later it was bushfire affected, even though it didn't say the 10.7 certificate.
Wow.
So you can do your due diligence by just getting the copy of that, tick, fine, no problem, okay? And if I was them, I'd probably do the same thing and just rely on that, okay? But if you delve deeper into the site, a local agent or a buyer's agent, someone with local knowledge might say, well, hang on, I remember there was a big flood, or this. Let's check if it's flood affected the site. So again, due diligence is pretty key in all of this. I'm not saying that it's not an obvious thing that would have gone undetected. Like if a property's heritage listed, you would know. It's pretty clear. It's heritage listed. It's on the 10.7 certificate, and your conveyancer, your real estate agent, someone would be able to pick that up pretty easily. So this is it's a problem that I see across councils. Bushfire and flooding are things that are often kind of, hidden somewhere if it's not on the 10.7 certificate. So it can come up. So I must admit, it's unfortunate that perhaps they didn't pick it up, possibly because it wasn't easy to find. Very few councils have actually their own mapping system, so you can punch an address and it'll say flood affected or bushfire or heritage. They'll have all these layers, but some councils don't have that yet.
But it's not just people that are on the water, on the ocean, or around sort of bays, etc., that can be flood affected, right? It can be lots of parts of the suburbs that are low lying, etc. So, do you find that sometimes people are surprised that they wouldn't assume that part of the suburb is flood affected, and they, years down the line they find that out?
Yeah, 100%. And all the rain and floods that we had a year or two ago with the La Nina and all of that, it really, I guess, put on the radar this council's flooding maps from an insurance point of view, as well as in situations like this where someone buys a property and they don't know it's flood affected.
Bushfire is an interesting one. We bought a house last year and it's literally backing onto a reserve, and we knew that straight away, right? So we got a town planner in at the Northern Beaches Council, but then it was like an education process. What's the different BAL 40 or the BAL flame zone, and what does that mean? What does that mean from what do we want to do a renovation? How does that put our costs up? And then we had to speak to some architects who had done renos on what did they have to do, shutters, etc. And so it is like once you found out the information, then it's like, how bad is it? Is it a risk worth taking on? Was there insurance issues? We had to call up insurance companies to find out would they insure the place, etc. So, yeah, I think it's and at the end of the day, it might not be a deal breaker. Like for example, a heritage facade might be something a good thing, but at least you're aware of it. And I think that's the problem when you don't do due diligence is that it can really come back to bite you down the line. With the flame zone, is that something that is quite common, across our sort of cities? Or do you think that, people assume that, they've never seen a fire there, so they just, could be a little park in a street, etc. So how common is it across our capital cities?
Well, it depends where you're at. I'm personally based in St Ives, so probably a few hundred metres from a national park. So we're living here, we're very familiar. There hasn't been a bushfire even, guys, since I lived here.
That's right.
But it depends where you are geographically in Sydney. In saying that, you might be sitting on a site where it's not perceived as being bushfire affected, but you might be a few hundred meters away from the bushfire, from the national park, and your site might have a high BAL rating, bushfire attack level rating, because there's a few trees between your house and the national park, and the fire can naturally jump and reach your home. So you've got to, it's all part of the process of due diligence, and it's not a foolproof process. I must admit, we're human, we all make mistakes. Again, it's not like a heritage listing or, something easily detected on the planning, on the council maps or on the planning certificate. It's something that also can be very subjective. And you have two different flooding engineers looking at a map. They might see differently. Just like two bushfire consultants might read a map and say, well, hang on, it's at this BAL rating on that BAL rating. So it is, in a way, there is a system though to measure these things, right? I'm sure I'm not an engineer, I'm not a bushfire consultant, but there are systems in place to measure these things. But sometimes you've got there's a human element involved.
We interviewed, unfortunately, I can't remember her name, but I do remember the book. The book's an amazing book, and it's called Brisbane, a river with a city problem, some episodes back. And it was really fascinating around, I guess, the creation of the real problems around flooding in Brisbane. But also, and one of the things that Megan Wells, who's my partner in Home Buyer Academy, she's a Brisbane-based buyer's agent. She talks about overland flooding. Everyone thinks about flooding sort of a wall of water, coming from a dam that's overflowed, or perhaps a river system that's flooded. And I was actually in Brisbane last week, and literally going up and down the river on the ferry, just sort of visualizing, what had happened and what had been devastated, et cetera, et cetera. So just an interesting sort of, I guess, thought process. But it's not just the overland flooding and the floods from rivers and drains and things filling up. And I've seen low-lying areas in Sydney flood as well when there's been a deluge of rain. But recently we saw a property that was flood affected, even though it's not in a low-lying area, and apparently it's because of an underwater spring. So it's just phenomenal where water can come from, when there's too much water in the system. So, and I guess I'm a little alarmed that you're saying that the councils can be, and I know there's an inconsistency from council to council. We know this in our own due diligence process in our business when we're buying property for people, that some councils' websites are really amazing, and we always make sure we speak to a council town planner as well, as relying on what they have online. But the very fact that the 10.7, which used to be known as the 149 certificate, may not be up to date, even though their maps may reflect something different, that is absolutely alarming. So, it's bad enough in terms of trying to get the information to make good decisions buying property and knowing what you don't know, but that's actually freaked me out a little bit, I have to say. Would you say that is common?
Yeah, it is very common, unfortunately. Yeah, like as a planner, town planner, we're very into numbers and calculations, and also the legislation, things that are written. The building has to be this high, it can't go smaller, bigger than this in terms of, when it becomes a subjective thing like flooding, bushfire, those types of natural things, it becomes tricky to predict. Number one, what are the impacts? And number two, okay, I'm on a flood affected site. My building has to be raised a bit higher, could be 300 mil higher than the flood level. Even I've had approvals for clients even where the council says, okay, your boundary fences have to have a gap certain height. So in the case of a flood, the water just rushes through and over to your neighbour or whatever. So you have to, I agree. It's not people think about a flood, near a dam or whatever, like you've seen recently in New South Wales. But in like metropolitan Sydney, it becomes a very real problem. But I've had, speaking about building heights and things, I've had projects where the property was flood affected, and what we proposed to council is the building has to be this high, but that'll breach the height limit.
Yes.
Right. Yeah.
So it's a double-edged sword while we're trying to make sure that if there is a flood, God forbid, the residents won't, be impacted as much. we need to tick a box with council. So it's a bit of
You got a sandwich. You got a building that's sandwiched between a height restriction and a flood restriction. God. So tell us, what are some of the other things that people erroneously assume that they can do that you come across with their own properties in particular?
Removing trees, probably, but they might be in the middle of your site. You just want to clear so you can put, townhouses or something. So trees is a real issue. Also sloping sites too. So what we're talking about are all natural features of a site, right? If the site slopes to the rear, as you guys would probably know, it usually requires an easement through your back neighbour. So when you're doing a simple due diligence, if the site slopes to the rear, you might be able to get a beautiful house approved or development approved, except you need to channel your stormwater through your back neighbour, acquire an easement, which is an extra cost. Your neighbour's probably going to say no. So then what happens with your house or your building, your approval? So there's a lot of factors. We can talk for hours about due diligence. But people make mistakes all the time. People are human, as I said before. But as a town planner, as an advocate for the client, it's our job there to ensure the risks are as minimal as possible, number one. But number two, say, as well as this is a DA. If it's a DA, it's not guaranteed to get all approved, even a complying design. However, if it's a CDC, complying development, it has to tick the boxes 100%. So naturally, you would comply, and it would get approved. But when you're dealing with councils, and I have to give my clients a disclaimer, we'll do everything physically possible to get you an approval, but we have, even though I've worked at councils before, we have no idea what else council can throw at you and what's underneath the side and things like that.
Because you do, it's true, and you said some things are subjective, and I know my own personal experience in dealing with council, you sort of think, which town planner am I going to get to assess my application? And some of them have a reputation for being particularly difficult, and others have a reputation for being particularly pragmatic, shall we say. And so you sort of cross your fingers and hope that you actually get a pragmatic one, not a difficult one. Also, what I guess scares me, you talk about potentially a site that slopes to the rear, which means that because stormwater runoff, goes downhill, obviously, and so therefore it's going to continue going downhill. And there's all these things you have to put in stormwater pumps and pump it up to all that sort of complicated stuff, which adds cost. But when it was first subdivided, did nobody think of that? I mean, does this happen in infill sites, like as established suburbs that perhaps were subdivided maybe decades ago when none of this was really thought about? You would hope it didn't happen in a newer subdivision. Or does that happen? Is it because somebody, when they first developed or first subdivided the land, just failed to account for this?
Yeah, good question. So with infill developments within existing suburbs of Sydney or whatever city you're in, it's a consequence of bad planning. It's not just bad planning; it's lack of data. Like now, you can get flooding information on your computer. 50 years ago they didn't have that information, right? They had maybe a little map where someone just sketched, okay, there's a flood here. Let's just maybe here, maybe there, we don't know. So the data we've got is a lot more accurate now. In terms of new release areas, you go northwest, southwest of Sydney, which used to be farmland, and by the way, probably flood affected. You do have new homes, but obviously the council and obviously the developer in their wisdom have put in parks in the middle so that the water drains into the park and things like that. So it has been done properly, I hope.
Ellie, on the CD, so just in terms of let's say someone's listening to this and they've just got a house, for example, not say a strata unit, etc. Could you put what things can you do without any approval? And what things usually are in the CDC sort of compliant development buckle, and then what things are sort of in a DA? Just that. I guess that simplicity there.
We'll break it down for us. Yeah.
So you kind of categorized it pretty well. So there's three streams of an approval in New South Wales. The first is exempt development. The second is a CDC, so complying development certificate. And the third one is a DA development application. So we've kind of been speaking a lot about DAs and a little bit of CDCs. So what is an exempt development? So exempt development is it's basically a self-assessed test. So I was in a seminar many years ago where the people that introduced or put together these controls, these state government controls were there, and they said, you know what we did? No joke, they told us this. They said, we went into Bunnings and walked around and looked at all the things you can do without approval, like a gazebo, a deck, pergola. This is how the exempt controls came to fruition. And they walked around Bunnings. This might be a plug for Bunnings. And that's how they developed this list. So there might be, let's say, 50 things on that list, even like an aviary and all these things you can do without approval, thanks to Bunnings. So essentially, something that's exempt development is essentially like let's say a cosmetic improvement to your home. So it could be you want to replace the windows, like for like, on a house. You can do that as exempt. You can paint, you can render, you can do it, put up a deck in the back garden.
Is there a certain size though?
I was about to say there's restrictions, 20 square meters, 25 square meters, can't be nailed 100 mil from the boundary. There's a lot of these restrictions attached. So essentially, you have all these types of things you can do, and then within each category you have restrictions, like the size, and it can't be on a heritage property or things like that. And it's a self-assessment tool. So you get your builder, you say, please build me this deck, it has to meet these requirements, and you yourself tick your mental box, the physical box, say, yes, it complies. That's it. You don't have to do anything. You don't have to tell your neighbours nothing. You've got an exempt, you've got a deck outside your back garden that's exempt.
What about a bathroom renovation?
Yeah, so the internal renovations you can generally do without approval. If it's like a structural change, if you're going to knock down a wall, you can often do that through a CDC. So through I don't think we spoke about it before, but a CDC is something where you lodge to a private certifier instead of going to council. So, the structural walls, if you do internal reconfigurations, like you put a bedroom where there was a bathroom, or the kitchen goes where rumpus, that type of stuff also can sometimes need approval of some sort. But generally, I guess the rule of thumb is if it's cosmetic, you generally don't need approval. So the second tier is CDCs, so complying development certificate. You can build a new house.
In certain locations.
In certain locations, subject to certain size, not flood affected, not bushfire affected. In those, you can also build a warehouse. So if you've got the right site in the right location in New South Wales, you can build a warehouse under a CDC up to 10,000 square metres of floor area.
Even multiple dwellings, right? Like townhouses in some suburbs that you can basically buy a block of land and lodge a CDC and know that it's going to get approved in a short time frame, right?
Yep, townhouses, dual locks. You've been able to granny flats. So for the last, I think, 15, maybe 10, 15 years or so, you can do a granny flat under this system. I think granny flats were the first type of development you could do under a CDC, and then it evolved to houses and industrial buildings, and you can also do, like, if you've got a business, you want to put a restaurant there and it was a clothing shop, you can get a change of use for a fit out. So there's also retail benefits too. But it's benefits to the retail industry too. There's complying development route.
So were they created really just to streamline, because there was just so much red tape and the bottleneck of obviously of council approval to in non-sensitive or insensitive, non-sensitive locations where the impact is minimal, to others or whatever their concerns are about the impact, to streamline the approval process so there wasn't the bottleneck. So it's amazing that we've got this sort of supply shortage that we have at the moment. Imagine it would be a lot worse if there hadn't been a move towards CDCs in some locations.
Yeah, that the intention was that most of applications in New South Wales would be CDC, and there would only be a handful of DAs. But as we all know, Sydney is not a flat topography where there's no trees or bush or flood or beaches or water streams. It's a very mixed topography. So naturally, more often than not, you are having to lodge DAs. Plus, also people want bigger homes too on their plot of land. So with a CDC, you can only build this much, whereas a DA might be able to build it this much.
Right. Yeah.
But Chris, you were saying your property was in a flame zone, so you can't do a CDC road. But I've heard situations before where if you were to lodge a CDC, you would actually get more floor space than with a DA. I don't know if that happened in your situation, but there's pros and cons for both. But actually, the idea of exempts. There was a time when I was working at a council where people wanted to install solar panels. No, this is probably 12, 13 years ago. Solar panels back then were pretty new and obviously expensive. And we were telling people, you need to lodge a DA for a solar panel. And then people worked out, well, hang on, why don't we just throw it in there as exempt? Okay, so it's exempt now. But then the question came up, well, what if your property is heritage listed and they plonk some solar panels at the front of this beautiful terrace or whatever it is in Newtown? And that's a no-no. You can't do solar panels at the front of the property. So the controls have evolved, and I think it's been done in a clever way, like starting from going to Bunnings and working their way down. For example, during COVID, also there were controls that the government released to help businesses also. So it's a wide range of applications, CDCs.
Ellie, if you get it wrong, right? Let's say you build something that should have been a CDC or should have been a development application. When does it really start to catch you out? Or you buy a property. We often see this actually, that something hasn't been approved or something has got a pool compliance certificate. The deck wasn't approved. Bedrooms have changed. How does it? If they sell it, how does it all play out? When does it catch you out?
I'm on a personal mission to help more people make better property decisions. And you can find out all about what I'm working on at veronicamorgan.com.au. And there you'll find resources for first home buyers, details about my buyer's agent mentoring program, access to suburb help for investors, or if you're looking to buy your dream home or an investment property in Sydney's inner west, eastern suburbs or lower North Shore, you can connect with my team at Good Deeds Property Buyers.
If you're thinking about buying your first home, upgrading to a new one, or purchasing an investment property anywhere in Australia, we would love to carefully guide you through this journey and importantly get the finance right. Please reach out via our website, wealthful.com.au.
Don't forget that you can download our free full or forecaster report. Which experts can you trust to get it right? theelephantintheroom.com.au.
So the way to, resolve it in New South Wales is something called a Building Information Certificate, or a BIC, a BIC. So there might be a granny flat out the back that was been there for 50 years. What do you do with that? So maybe we'll take that as an example. So you can either leave it there, nobody will know, right? But in most cases that I see, it's only where the neighbour has complained, and that's where the council has to follow through the complaint, and then you have to go in there and patch things up with, you have to pull down some walls or whatever. You have to fix things because chances are it wasn't built to comply with not just the council controls but also the building regulations. So you have to. It's a bit of a cart before the horse situation. So you've got to, fix what was done, and most cases it wasn't done properly. So you'd have to either have an alternative solution, or you have to knock some parts down.
In your experience, are councils prepared in the balance of examples? Are they prepared to negotiate and work with the owner to come to a resolution, or do they dig their heels in it and say, "Nah, you got to demolish"? I mean, I have come across some examples in my own working history where people have been told they had to demolish or that to fill in an excavated room, or some fairly drastic sort of solutions. But I've always also got the sense with those examples that I've been aware of that those owners had aggravated council to the point that council just went hardline with them. Would that be fair to say that, or would you say that there are different councils or different different jurisdictions perhaps that are more likely to force you to make good than others? I mean, how pragmatic or how commercial are they?
As you were kind of alluding it to before, it depends who you get in council, ultimately. And there's not one council that's better than the other, really. We've got projects in probably almost 30 councils around New South Wales. And, it's really hard to pick or choose, tell you which one's the easiest to work with. But I like to tell people it's a partnership. It's us and council working together to get an outcome for your client. Because it should have really been us versus them battle, because otherwise, as you said, it's just going to get messy and you're going to end up in, current affair. It's just messy. So you've got to work together, and you will probably have to make compromises for your client, like knocking down a wall or filling in that excavated room. Because sometimes, believe it or not, don't tell anybody, I'm sure no one's listening, you can't always get what you want.
Oh, I know. It's just such a shocker, isn't that?
And it's your piece of land, I agree, except there's rules and boundaries that you have to follow. Otherwise, you'd end up with a disaster of things going on. Like, speaking of unauthorised work, you'll like this one. At another council I used to work at, the building officers used to come to us town planners for questions they had about some illegal work or vice versa. So once one of the building officers came to me and said, look at this. This was, I'm not saying where it is, but somewhere in Sydney, someone had a pool. They emptied the pool and put a roof on it. Okay.
Oh my God, that's wrong for so many reasons. So many reasons.
It is unbelievable. I would have mind checking it out myself. But, people do all crazy things. Some are naive, like these people in this, that we're talking about in this flood affected site. Whereas some people that try to be sneaky and squeeze things here and there, and that ultimately they will get found out either if they sell the property, like what you were saying, or one of the neighbours is going to dob them in. Most of the time, they'll get found out.
Ellie, on the lodgement of DAs, would you say there's potential? Let's say you're trying to push the boundaries, right? Let's say the council controls and the neighbours are all, the NIMBYism is rife in the suburb and everyone doesn't want change, right? And you're going to get lots of objections. Do you find that sometimes people go for a lot more than ideally the nirvana of what they want, right? But they sort of say, they freak people out and they say, look, this is what I'm going to build. And then they know they're going to have to make compromises, right? And that is part of the negotiation process, is that I could have built X, but now I'm doing X minus 3. Do you find that that's potentially a strategy that, that sometimes works in terms of if you go in asking for that and then they're going to ask you to negotiate anyway, so you sort of have to go in and ask for potentially the dream and then start making cutbacks?
100%, and I think it's appropriate to say that's probably called the elephant in the room strategy. Because sometimes you do. You might say, okay, you want, especially with larger developments, I guess, you want council to approve this, but hang on, what about that? Let council draw their attention to that while you get this, approved on your project. So that's one strategy.
Or
right?
you're going trying to get 40 stories where you've costed it all along at 35 and
yeah, 100%. Yeah, you do that all the time. And also with a home renovation or as you said, a large development, you can do that. But also there's, as I was saying before, you need to give your client realistic expectations in terms of what you think they're going to achieve on their property. So for example, you might go for a project that involves 10 apartments, right? Except the default position is, okay, what we need to scrape this through to make it a valuable project is 9 units. Okay, so you go for 10 and chop it down to 9, make them a little bit bigger, or whatever the case may be. So there's always a backup plan with tiers. Even if you build out the carport, in the front of your house. I wouldn't stop you need a backup plan because there's absolutely no guarantee you're going to get approval. Number one. Number two, you also, for sure, you can try push the limits if you want, but you have to know there's going to be a risk. It's going to cost you more. It's going to take you 6 months to get an approval. Plus your neighbours will object to your application because it's blocking out their view or whatever it is. It's way over the floor space or the height control. So there are strategies where for sure you can do that with, seasoned developers. For mums and dads who just want to get their, project home or their renovation approved quickly, you have to bring them in line. And that's what I was saying before that I do. You've got to bring clients in line as well as sometimes architects who might think, we can do this, but hang on, you can only build this. And so sometimes we have to find a middle ground. Okay, we'll come to an internal compromise that, okay, we'll lodge this and let's see what council says. Council might say, well, no, we have to bring it back even further than what we expected. So yeah, it's a strategy we use all the time.
When the irony is, though, it's your home, right? So if you go and piss off all your neighbours, and you fight with them for multiple years to get the home that you ultimately want, and whether you get it or not, you've already pissed them off, right? Then you finally build it, and then you want to live there, and every time you leave your front door, you bump into your neighbours, right? And so it's how do you sort of tackle the neighbour where ultimately it's your land and you want to get a home that's amazing for you and your family, right? But then it's also going to compromise something towards them, whether it's light or privacy or their view or I don't know, whatever it might be. How do you best approach that? Do you find?
Yeah, good question. I tell people, unfortunately, you can't choose your neighbours, right? But what I do tell them is, if they're going to lodge a DA, before they lodge the DA, go over to your neighbour's house with a set of plans, preferably with your architect, like your town planner, because your architect drew the plans. They know what they're talking about, and say, hey, this is what we're going to do. Now, obviously, this is in the context of a DA, because something we didn't distinguish before was if you're lodging a complying development, the neighbours don't have a say. They are notified formally. It's just a courtesy saying we've approved this new house, or whatever is next door to you, and that's it. With a DA, there's an ability for neighbours to get involved. So I guess that's in this situation you're talking about, Chris. So get them involved, at least show them the plans, and they can say no to different things, and you can say yes, okay. Yeah. You don't have to agree on anything, but they might want a privacy screen here, or lower the deck here, or the pool should be here instead of there. You can, sometimes come to a compromise with them, whereas sometimes you might just not listen to them at all and lodge your DA. Your neighbour will object again, object formally, and then you have to make some changes just to appease the neighbours. I'm so say so, but in that, I guess, let's call it that consultation period with your neighbours, you don't have to make any changes. But council, and you can tell them, your neighbours, okay, we're going to lodge this, and let council be the umpire. They're going to be the umpire. If they like it, they like it. If they don't, then that will change it.
It's an interesting one, though. I mean, I've done 3 renovations, and each time I've approached the neighbours beforehand, and then you as the person wanting to put through your development and be reasonable with your neighbours is one thing, but you can't always guarantee you've got reasonable neighbours. I've my neighbours now are amazing. They basically said, look, we're all for the whole area being improved, and we're supportive of that, and so, and I worked with them on just a couple of little things that were important to them, and we made compromises as well. Whereas I've had other neighbours who've been fantastic also, but other neighbours who've been very resentful and dug their heels in, and I've had council say things like, like loss of view, and I had another property in Balmain, and they said, well, you can claim loss of view, I think, tell me if I'm wrong, from, say, a living area, but you can't claim it like from a bathroom or from your laundry. And yet, because we had an elderly woman over our back fence who said, well, no, I can stand on my laundry step and I won't be able to have the same outlook, they actually seemed to sympathise with her, as opposed to, but it's your laundry step, And then the councillor came up to me and said, don't worry, you could actually plant a big tree there. And I just couldn't believe that the councillor came and took me aside and said that to me. It was like, Right. Okay.
Yeah, well, you described it quite well. Like, if your project went to court, they wouldn't even consider that as a view from the neighbour's laundry step. Yeah, it's again, just like dealing with councils, your neighbours, it's a compromise and something, like I should say too, like as a town planner dealing with multiple councils at one time, but the councils are not going anywhere. So you need to have a good relationship with them, and we can have a whole discussion about that another time. And the same goes with your neighbours. If you want, Chris, you were saying, if you lodge an application, your neighbours just, you end up building it, you might not want to live there anymore.
I've come across lots of people who've sold after that experience. Yeah.
Well, that's why reason I said it. I've known someone who's done that, right? They've gone through it, the stress of it all, and the end of it, they just, can't leave their house. They just are pissed off the neighbours too much. When it goes, and I've got a client at the moment, it's one of the most expensive suburbs in Sydney, which, to be honest, it is a bit of I feel like it's a suburb where everyone's fights because they know it's worth so much money, right, in this suburb, lower North Shore to get a DA approved. Everyone's fighting for their DAs, right? So it's almost like everyone's pissing everyone off in this suburb, right? And it's not going well. It's sort of it's in the courts, right? So when you mentioned the courts there, like, can you explain when it starts you lodge it with council? Council's got objections, neighbours got objections. How it sort of goes to different courts and who sort of ultimately makes those decisions where there's these all, because it's not just as black and white as, right, it's declined, right? There's appeals and how does that sort of roughly play out?
Yeah, so there's a good question. So there's two options for going to court. So one is where you lodge your application. Your DA might be a home renovation or a block of apartments or anything in between. Doesn't matter what it is. You lodge a DA, you wait 42 days, and then you lodge your appeal through the Land Environment Court. That's one option. The other option is you lodge a DA, you wait however long it is, and your DA gets refused. You can appeal that decision also within 6 months of that refusal date. So those are kind of the two ways to, I guess, get your foot in the door in court. The going to court is like a whole nother podcast and a strategy, but it's similar, I guess, if you jump back to what we were talking about before, in terms of a strategy. You put your plans in for this, it's a little bit higher. That's a strategy, and you can take that to court, knowing that top level, whatever is going to be contentious, and then you can thresh it out with counsel in court, and you may end up just losing that top level in the end. So there's strategies for the actual design of what you're going to build. If you're not planning to take something to court, then I would say you design a little bit differently. You don't be as let's say bullish.
Yeah, it's a good question there, Chris. I'm glad because I hadn't even thought about taking this conversation there, but because I've heard a lot of people say they basically lodge their plans with the intention to go to court. And I also know there's an area like Birchgrove, for instance, a little suburb in Sydney that seems to find its way on every single top 10 list, whether a market's going up or down. But that's quite it's well known locally. It's another reason to use a local buyer's agent. You mentioned earlier, if you're going to use a buyer's agent, use locals because they know this sort of stuff. We know the particular pockets where the neighbours are particularly, anti-development, even though they've probably done their own quite.
It's special. Yeah, Birchgrove is special. I had a project in Wharf Road.
Oh, there you go, Wharf Road. The Wharf Road, mafia is basically that's what I was thinking of.
Yeah, it's a special area. Yeah.
It's a very special area that everybody objects. Everybody knows that everybody objects, even though there's lots and lots of new development that goes there. People knock down houses all the time and rebuild quite, ambitious sort of projects often. Is going to court the province, though, of people who have already got a lot of money? Is it an attitude that is like, you know what, I can afford to get what I want and I see everyone else around me getting what they want. They just have to, add another 50 grand or whatever they allocate to the budget to force it through to get what they want. Is that part and parcel? Is it a privilege of being in an area with very, very expensive property that you can afford to buy in the first place and renovate and then also push through in an aggressive way, would you say, or is that being a little bit...
Well, no, you're 100%. Yeah, going to court is not cheap and a cheap exercise. I'm involved in multiple court cases at the moment, and a couple of years ago we had a childcare project that took, I think, almost 3 years. Ended up in court, got refused based on a very small technicality. And the client said to me, Ellie, I've spent 330 grand.
Well,
And what did I get for it? So he was a developer, mind you, wasn't just a regular mum or dad, but still, it's a huge cost. So I agree with it. Depends where it is. But at the same time, like having clients of mine in the eastern suburbs that just want a car space on their little block of land. And do you know how valuable that one car space would be on a little block of land in eastern suburbs? They're prepared to go to court for that. And I have been to court for those things before, and we've been successful. Just for a car space.
Sorry, the court option is like if the council sort of does decline it or refuse it, right, let's say, but you genuinely think that it should be approved, and then you basically hire legal representation. But the council's also got legal representation, right? They've got their own lawyers, and you're sort of trying to negotiate your way through, even though it doesn't fit policy or the regulations or the guidelines, you think that it should be approved. Is that sort of generally where that, you know, you do a development that maybe is pushing the boundaries a bit, or it is going over the height limit, or maybe it's going too close, or the setback, or the ratio is a bit high, but maybe you're planting, you know, is it sort of part of, if you're doing something that maybe is pushing the boundaries, you have to really get great legal representation, and that should be part of your overall process, is knowing that this is the avenue you're going to have to go down from the start?
To kind of answer that question, I'll start off with the process for court. We didn't discuss that. There's kind of 2 steps. The first step is mediation, and then the second step is a hearing. Now, both of those steps is in front of a commissioner, so of the Land Environment Court. But most times, I saw a statistic the other day on LinkedIn, I think almost 50% of court cases are resolved through negotiation. So likewise, I've already been in a full hearing a handful of times where you get cross-examined by lawyers and things. It's, you know, sitting in a courtroom where it's a bit scary sometimes. But most of the time, going to court, Land Environment Court is not sitting in a courtroom. It is sitting at a table with counsel. You on one side, them on the other side, which sometimes is very hard to catch them in a meeting. That's sometimes why some developers take counsels to court, because they simply can't have a meeting with them. And you sit down and go through, okay, these are the issues. Literally, you get a list of all the issues. Okay, there's 20 issues here. Let's discuss each of them. You go through it systematically. This one we can resolve. This one will bring the height down. It's 10 apartments at the moment. We'll lock it down to 9. That'll tick a lot more boxes. So it becomes a negotiation process. You do have to make compromises going to court. So whereas you would think that in the context of keeping your DA in counsel, you're not privileged to that option of negotiations, to that full extent of negotiation. So that's why people go to court.
Which is interesting, because the thing is that, okay, so if you get to mediation, they're basically forcing counsel to come to the table with them. But if it actually gets to court, it goes purely on the letter of law, right? So they're basically interpreting, because LEPs and DCPs are all legislated, correct?
Yes.
So that's why it becomes a law thing, right? It's really about the wording of the law. As opposed to, well, I don't think it's fair, I should be able to get bigger floor space, or I should get another level on. It comes down to how the interpretation of that legislation, right?
Yeah, and you have experts too, experts in court. So you'll have so obviously your employer, you have a good team. Chris was saying you need a good lawyer, so obviously a good lawyer, planning solicitor. You need your experts. So your experts usually include your town planner. If, let's say, it's in a heritage area like Birch Grove or somewhere like that, you need a heritage consultant who is your expert. It might be in a flood-affected area. You have your flood expert, the stormwater expert. So you have, depending on the size of the development, you might end up with at least half a dozen experts on your team, and each of those consultants charge by the hour. And obviously that fishes up the price of the project, but still your experts are there to talk to council's experts. So we've had situations where the commissioner will tell us, well, let's say there's 3 experts today, each of you go into a different room or whatever and talk about it. And that's what you do. You talk about it, and you go through all of the issues and say, okay, well, this is reasonable, this is not. In most cases, you can end up with an approval just by talking to people. And some councils, they're depending on the type of project, also depending on the number of objections and the interest. Like for a lot of the childcare centre projects we get involved with, as they are contentious, we have to take it to court because you might have 50 or 100 objections, and how can council approve a childcare centre with 100 objections?
Yeah, and look, obviously, the bigger the stakes, the more potentially the payoff from going to court as opposed to an individual homeowner. But there's one thing we haven't talked about before we ask you your dumbo, because I'm sure you got plenty for us. The pre-DA process, because in a way that's sort of sitting down with council before you actually lodge a DA and Freudian slip delay, and trying to understand whether what you're thinking you want to do is actually likely to be within the realms of possibilities. I know some people advise, some town planners and architects advise not doing that, not alerting council to what you're thinking, and others would never do one without doing a pre-DA. What are some of what do you think of that as a part of the process?
Yeah, so pre-DA is essentially where you lodge your concept plans to council and have an upfront discussion with them. Now, you would only lodge a pre-DA, I think, if you're pushing some things with the council regulations, number one. Number two, if you've never worked in that council before, like we've done projects in regional New South Wales where we lodge a pre-DA for every project because we don't know exactly what the council requirements are, for example, or but at the same time, we would usually have a pre-DA with council, and we would know 90 to 95% of what the issues are going to be or what's going to be discussed at the meeting. But there's always that 5-10% where, okay, well, by the way, council might say, it's flood affected. Or, there's we had one recently for a childcare centre in Hillshire Council, and they told us, by the way, right behind your site, there's been an approval for a retirement village, which we didn't know, which was very helpful because now we're going to be designing this childcare centre knowing that there's going to be however many balconies overlooking my client's site. So the pre-DA is an invaluable exercise. I hear people when they say, pre-DA, they're just going to tell me what I already know. Yes, most likely. But I've had at least one council officer tell me, you should lodge a pre-DA for something that was pretty trivial. And we lodged a pre-DA and it got approved after we lodged it in a very quickly and easy manner. So it's a strategy too. Again, we'll go back to the strategy of having a relationship with council. If you were to knock on your council's door tomorrow and lodge a DA for, 100 units and say, hello, we're here, that's not the way to do it. You have a pre-DA meeting, you consult with council because you're working together. You don't want to surprise them too much. On the flip side, there might be just a car space you want approval, or a new house where you think there might be some opposition, there might be view impacts, or so you're not sure. So have a pre-DA. We were talking before about Birchgrove and Inner West Council. Inner West Council they encourage you to have pre-DAs. We've had, I think, on one project 3 pre-DAs for 2 semis in Ashfield, because what it does is that it working with council in a heritage conservation area, mind you. So council say, do this and not that, and kind of working with council, even for a small development.
So you get a bit of buy-in from them, and hopefully that's the greases the wheels. Yeah.
So the pre-DA meeting, they'll tell you these are the issues, and you'll be able to work through, I think, 90% of the issues. You'll be able to address most of them. So what we do is when you come to lodge your DA and prepare the DA, we say, we've had this meeting with counsel, these are the issues, and this is how we've resolved them. And there might be some issues which you still might want to challenge counsel for whatever reason it is, and then you'll end up with a much smoother process with your DA. It'll be much quicker for you, and also you're going to be eliminating the number of changes you have to make to the plans, because you'd already you have your set of plans with the pre-DA, and then you change them and your other documentation, and you lodge your DA with those plans that have been revised to address counsel's concerns.
Ellie, hit us with a dumbo, mate.
A dumbo.
Okay, I have a current client, and it involves an extension to a warehouse. This is a massive site in Western Sydney. So we're talking and all of this, and he says to me, quite a large extension to the warehouse. And he tells me, by the way, the client got an approval, let's say 5 years ago, for another extension to the warehouse. We're talking, let's say, a few thousand square meters of additional floor space. They had an approval for the extension. What's happened? They've actually built this extension without a construction certificate.
Oh, all right. People just think that, they don't we didn't even talk about construction certificates.
Yeah. This is not someone in suburban Sydney's put up a granny flat in the back of the house without approval. It has been approved, but they didn't get a construction certificate. They didn't. So with any DA, you need to satisfy 30, 50 conditions, extra reports and plans, and take it to your certifier, and then you can get your construction certificate. So I said to this this project manager, said, how on earth did this happen? He said, unfortunately, the client is not a local. They were scammed by an Italian builder who is now gone back to Italy and nowhere to be seen. And even I heard recently from him that even the construction certificate number, you lodge a DA, you lodge a construction, you get a number. Even the number was fake, it was false.
Oh dear.
So they thought they had a construction certificate, but they built it there.
And they built it. It is finished. And you think, where are the neighbours? Think this is an industrial site, so no one really cares what's going on there. And so I'm left with a DA that we have to lodge on this site that is next to something that's been approved, except as we were talking about before, something that is built without it was approved, but something lodged in this way, built in this way, probably didn't comply with the approval.
Yeah, okay.
In any case, even if you get an approval for a new home, a spec home, whatever it is, you build it, there's going to be one sentiment. It's going to be a few variations to what the final product. This is something that has not been screened or checked by anybody. And you learn something new every day.
Watch this space, I guess.
A big exposure, that's for sure. Yeah.
Ellie, thanks so much for coming on, mate. We definitely should get you back on to talk about. There's obviously a lot to talk about in an hour, so I really appreciate you coming on, and hope our listeners found that valuable.
Thank you.
Thank you. It was fun.
If you have a question that you'd like us to answer in an upcoming Q&A episode, you can send us a voicemail or written question via the website, theelephantintheroom.com.au, or you can email us directly at questions@theelephantintheroom.com.au. If you like what you're hearing, please share this episode with others you feel would benefit. And while you're at it, why not leave us an iTunes review? 5 stars would be great. I know that sounds a bit cringy, but we have it on good authority that every review helps make it easier for other people to find out about us and hear what our amazing guests have to say.